Good morning, everyone. I'm Carl Dubel. This is my contact information. I will put it back up at the end just in case anyone has any questions or wants to get a hold of me. Next slide, Kathy, please. So just a quick way of introduction. I'm an associate at Bond in the Rochester office. Before joining Bond, I was an assistant district attorney in Manhattan. During my time there, I focused a lot on Fourth Amendment issues and weapons possession cases. So this is one of my favorite topics to talk about this morning. So I'm definitely looking forward to it. I'm also a SU law graduate and a Liverpool alumni. I know there are some Liverpool people from Syracuse signed up for this webinar, so I wanted to give them a quick shout out. Next slide, please. So just a quick overview of where we're going to be going and the topics we're going to be discussing this morning. First, I'm going to start with kind of an overview of Fourth Amendment law and the principles that are important for Fourth Amendment analysis. Search and seizure issues are very fact specific. They're fast moving situations, and there's not a lot of one size fits all rules. So it's kind of important to understand these overall arching principles, and that helps you apply them to specific facts. My hope is that by understanding these general rules, you'll be able to respond to potentially different situations as they arise, in your roles, because it's kind of impossible to predict where, any one situation. So hopefully this presentation will give you the tools to kind of, go forward and not violate anybody's rights. Let's put it that way. Then we're going to move on to, traditional searches, searches of backpacks and jackets and pockets and that sort of thing. I'll talk about kind of the most important United States Supreme Court case on the issue, and that will give you a good sense of some specific factual situation, as well as the, important to keep in mind. With that, we'll go through some hypotheticals of, searches that are good and searches that are bad. After that, I'm going to talk about metal detectors and when they are permissible and when they're not permissible to use and how to use them effectively. There's a few warnings here, but the good thing is that the rules around metal detectors are pretty well developed, so there shouldn't be a ton of issues. After that, we're going to talk about canine sniffs and police dogs in schools. We'll talk about where, when, and how these police dogs can be used. And unfortunately, unlike metal detectors, there's a lot of different rules in this area, and there's a lot of gray areas and some not settled issues, unfortunately. But we will get to that bridge later on. Then towards the end, we'll talk about SROs and outside law enforcement. Sometimes the rules for SROs and schools are the same as they apply to teachers, and sometimes they're not. So we'll kind of talk about the situations of when the rules are the same and not. And lastly, just with outside law enforcement, we'll talk about how to respond if they ask to intervene on school property. Next slide, please. So first, let's talk about what is the Fourth Amendment, and there's kind of three important questions to ask yourself when learning about the Fourth Amendment. It's two who's and one what. So who does the Fourth Amendment protect? And the answer is private citizens. Who does it protect from? It protects from government officials and government action. And what does it protect? It protects against unreasonable searches and seizures, which we'll break that down later. So just kind of string that all together. The Fourth Amendment protects private citizens against unreasonable searches and seizures by government officials. Those are kind of important things to keep in mind. Next slide, please. Now, as school teachers or school officials, you might be wondering, why does the Fourth Amendment doesn't apply to me? Like, I've watched Law and Order, and I'm not a police officer. Like, why does this apply to me? And it is important to understand that students are private citizens for Fourth Amendment purposes, so they do have Fourth Amendment rights in the context of just coming to school. They don't leave their constitutional rights at the door. I'm not sure if anyone's heard that phrase before, but and then public school officials and public school teachers are considered government officials for Fourth Amendment purposes. So the Fourth Amendment does apply to you, and it's important to understand that there are some limitations on the actions that you can take when it comes to searching and interacting with students. Next slide. So now that we know that the Fourth Amendment applies to school students and that it applies to school officials, we get to the last question, the what. What is it protecting against? And it's, as I said, it's unreasonable searches. And to kind of break that down, there's the unreasonable portion and then there's the search portion. So the first question we have to ask, in any Fourth Amendment analysis is, what is a search? Has a search occurred? Because if no search occurs, there can't be a violation of the Fourth Amendment because the Fourth Amendment protects against unreasonable searches. And this is kind of a threshold question that is very important in this area of law. And I will get into kind of, how do we know when a search occurs? So next slide, please. There's two main tests to determine, what is a search. There's what's called, these come from Supreme Court cases, which aren't super important to know, but this is kind of, by way of background, that's where they come from. So the first is the trespass test, and the second is referred to the Katz test. But I'll talk first about the trespass test. This is an actual physical intrusion of a student's person or their personal belongings is considered a search. So if you're touching, let's say you're touching a student's backpack, or you're touching their jacket, or you're touching their pocket, that is, you're physically intruding onto their person. So that's going to be considered a search. Kind of what might be a physical intrusion, but what isn't a search is, walking into a common area of the bathroom and seeing a student doing something they're not supposed to be doing. That's not a search because you might be intruding into the bathroom, but that's not a protected area. The student doesn't have any privacy rights, out in the open in the common areas of the bathroom. So, that's kind of the distinction here. Like where you're touching something that belongs to the student, that's going to be a search. But when you're just, in an area that the student doesn't have any claim over or is in a common area and you see something that's out in plain view, that's not going to be a search. Okay. So that's one way a search can occur, is that physical intrusion. There's also, unfortunately, a second test for when a search can occur, and this is called the Katz test. This is a non-physical intrusion into an area where a student has a subjective and objective reasonable expectation of privacy. So one example of this would be scanning a backpack with a metal detector. Obviously, the metal detector isn't touching the backpack, so there's not a physical intrusion, but the student has an objective and subjective personal expectation of privacy in that backpack because they own it. It's their personal belonging. So that would be considered a search. Same thing with like a canine sniff. If a police dog sniffs a backpack, they're not really touching the backpack. There's not a physical intrusion, but the courts have held that is a search because, the student has subjective and objective expectation of privacy in that area. Kind of just to give some more examples of, what isn't a search, talking to a student, asking them questions, that's not considered a search. Seeing something out in plain view, seeing drug use in the parking lot. I don't know why a student would be doing that out in the open, but I guess I digress. But and then, anything you see in, common areas where anybody is allowed to be, those aren't going to be searches, especially when you're not touching anything that personally belongs to the student. As I mentioned before, these kind of two tests come from these Supreme Court cases. They're not relevant to the school law example, but just by way of explanation, the trespass test comes from, the police placed a GPS device on a person's car. So they held that, the police, by touching the car, trespassed on personal property, and that was considered a search. Now, Katz is different. Katz involved a person, the police wiretap. That wasn't really a trespass because the person didn't have any expectation of privacy in a public area. or they didn't own the phone booth, so it wasn't their personal property, so it couldn't have been a trespass. But it was a violation of their expectation of privacy, the courts held, because, if you're talking on the phone in a closed booth, you don't really expect anyone to be overheard. So those are the two overarching tests. Next slide, please. So if you search a student, do you violate their rights? And the answer is no. Just because you search a student doesn't mean it's a Fourth Amendment violation. To go back to the what, the Fourth Amendment protects against unreasonable searches and seizures. So searches can be reasonable and they do not violate the Fourth Amendment. And now we'll talk a lot about what is a reasonable search, what isn't a reasonable search. So next slide, please. How do we know if a search is reasonable or not? The general rule is that a search is reasonable if it was authorized by a warrant or a search warrant. And then by way of example, the FBI search of Mar-a-Lago and Donald Trump's home was authorized by a search warrant. They went into his private property and searched. That was reasonable because it was authorized by a search warrant. So does that mean you need a search warrant to search a student in school? And the answer is no, you don't. There are a million probably exceptions to the general rule of the warrant, what's called the warrant requirement. And there's the exceptions trying to swallow the rule because there are so many. And one of those exceptions is administrative searches, which includes school searches. And courts have come up with rules to determine, when is a school search reasonable without a warrant. And we'll get into that next. So next slide. So TLO versus New Jersey is the most important and most famous Supreme Court case, United States Supreme Court case on this issue. Just in case anyone doesn't know, the U.S. Supreme Court is the highest court in the country, so its rules apply to everyone, no matter what state they're in. And this is kind of confusing because you'll also hear the use of the word Supreme Court in the context of New York Supreme Court. The New York Supreme Court is not the highest court in the United States, nor is it the highest court in New York. So that can be kind of confusing. But this is the United States Supreme Court, so it's a very important issue. So we learned two big important rules from the TLO case, and that is school searches are permissible without a warrant when a school official has reasonable suspicion to believe that the student engaged in or is engaging in an activity that is in violation of the law or school rules. And the important phrase there is reasonable suspicion. And then the second big rule is that the search must be reasonably related to the scope, or reasonably related in scope to the circumstances that justify the intrusion. And we'll break down what both of these mean later. But I hope if you remember anything from this presentation is that reasonable suspicion is the legal standard by which a court is going to measure whether a search is permissible. So next slide, please. All right, it's been one slide and everybody's remembered the phrase reasonable suspicion, but what does it mean? What does it mean to have reasonable suspicion? So a school official has reasonable suspicion to search a student when they can articulate specific facts which would lead an ordinary person, the same training and experience as the school official, to believe that the student has violated or is violating the law or school rules. This does not mean that you have to have absolute certainty that the student is either committing a crime or doing something that they're not supposed to be doing. And it doesn't even mean beyond a reasonable doubt, which is another legal standard you might hear. And it really doesn't even have to be more likely than not. It's a pretty low standard. However, you do need what's called specific and articulable facts. So you need to point to something that you either see or you heard or you know that would suggest that the student is reasonably likely to be in possession of contraband. So, for example, student A or student X is a bad student. They don't do well in school. That does not create a reasonable possibility that on a specific day he is in possession of contraband in that specific moment. So just because a student is a bad student or they tend to get in trouble does not mean that you can search them at any day, whenever you want. But, kind of your past experiences with a student and their reputation in the school is not a completely irrelevant concept. Student X has been in trouble for possessing cigarettes in the you see him go in and out of the bathroom 5 times in a row in quick succession, and then you smell smoke when you walk into the bathroom. And then 30 minutes later, you search the student's backpack. Those are specific facts that point to that specific student doing something that's specifically against the rules on that day. It's not a certainty. You didn't see them smoking. They could have ditched the cigarettes, but it's a reason you have reasonable suspicion to believe that they are in possession of something they're not supposed to have. So that's kind of what is reasonable suspicion in some situations where you don't have reasonable suspicion. Next slide, please. The second big rule we get from the TLO case is where can you search? So school officials are allowed to search anywhere a reasonable person would think that the student possesses the contraband in question. This is an extreme example, but one that I think is very helpful and kind of highlights the issue is if you have reasonable suspicion that the student is in possession of an assault rifle or a large weapon, you can't search their pocket. There's no possible way that that weapon is going to be in their pocket because of the size of it. But if that student is in possession of cigarettes, you can search the purse. Why? Because a reasonable and ordinary person would think that that item of contraband that you believe that they possess would be in their purse. So important factors to keep out here. Where would a normal person hide or possess the item that you think the student is not allowed to have? Size of the item is extremely important in this analysis because you can't really, like I said, if you're searching for something really large, you can't look in an area that's really small that it would never be in. Common sense is also kind of a big important thing here. Basically where would you think it would be? That sort of question. Next slide, please. So let's apply these two rules to the facts of the TLO case, the reasonable suspicion and kind of the scope of the search. So the facts in TLO were this: one teacher caught two freshman high school students smoking in the bathroom. The students were then brought by the teacher to the principal's office. The principal searched one of the students' purses and found cigarettes and marijuana. So how did the court apply these rules? So the first one, the when can a teacher search? The court said that the principal had reasonable suspicion because the teacher had saw that the student was smoking and that you need cigarettes to smoke. So it would most likely, and it would be reasonable to assume that the student was in possession of them. This isn't a certainty. You don't actually know if they still do have them, but it's reasonably likely to believe. And kind of part two, where are they allowed to search? The court said the area of the search was also reasonable, the purse, because the student's purse was an obvious place to look for them. And the court actually said, her purse was the obvious place in which to find these cigarettes. So that, kind of common sense understanding is, important in that kind of step two. So next slide, please. So some modern examples. Like I said, TLO is from the 1980s, and it's fair to say that cigarettes are probably declining in popularity since then, but there's also a very obvious modern equivalent to normal cigarettes, and that's vapes and e-cigarettes, which I'm sure are common problems in your schools. So let's, for one example, teacher catches student A vaping in the bathroom. Student A says that B sold her a vape that morning. Teacher then searches student B's backpack. Here, let's go through the analysis. Did they have reasonable suspicion of impermissible conduct by B? Yes, the teacher learned that student B was selling vapes, so it's reasonable to believe that they were going to to sell them, they have to be in possession of them. So it was reasonable to suspect that they were in possession of a vape or an e-cigarette. Now, was the scope of the search reasonable? Yes. That like with cigarettes, a vape is a pretty common item that would be stored in a backpack. So it was totally permissible to search a backpack. Let's see, I'm seeing some questions in the chat. I will, there's 2 points where I'm going to pause and kind of read them. So I'm not trying to ignore you, but I just saw them and I will try to get to them. Okay. So let's go through another example. Student C is always late to class. Teacher searches student C's backpack, assuming that student C was late because they were vaping in the bathroom. This is likely going to be considered a bad search. Student C could be late for class for a million different reasons. That does not mean that they were late because they were vaping. So in that situation, you don't really have a reasonable suspicion because you don't know why they're late. You have no background facts or specific facts to suggest that they were late because they were vaping because they were late. Next slide, please. So when do searches go too, like where can you search, and when do they go too far, when to stop? So let's say in a situation you think a student is in possession of drugs for whatever reason. You search their jacket, their outside jacket, you pat down their pockets, maybe you look through their backpack, but you don't find anything, but you still think there's a good basis to assume that they're still in possession of drugs. At this point, it's probably a good idea to stop and get law enforcement involved. Searches that require students to, remove any sort of inner clothing are looked at much more carefully by courts. And that would make sense because, those kind of searches involve much greater intrusions of personal privacy. So you're going to have a better reason to do that. There are permissible reasons for those kinds of searches, but some of our school district clients out here in Rochester are shying away from being personally involved in those kind of intrusive searches. So at this point, it's probably if your search has to go beyond pockets, jackets, backpacks, that sort of thing. It's best to get professionals involved at that point. So this is actually where I was going to stop and try to pick questions. Someone is asking a copy about the presentation. I can probably send that to you. If you, I guess it would probably be best for you to reach out to me individually and I can try to send you my slides. And then the next question is, does a report from another student saying that student said that they were bringing vape pens on a field trip and asking someone to hold it reach this threshold? So I guess this would depend on the answer of, of course, it always depends. But, kind of reports generally or hypothetically reports from students that other students were doing something permissible. If that's happening immediately, then yes, that would still meet the threshold of reasonable suspicion because, a student comes up to you and says, I saw student X vaping in the bathroom 5 minutes ago. That gives you a reasonable suspicion to kind of approach them immediately or in a reasonable period of time and question them and potentially search them about that. If in this hypothetical, 3 months after the fact, student X says, student Y was vaping in the bathroom 2 months ago. And then you go and, you can go and question student Y about this. But, just because they were doing something illegal or impermissible 2 months ago does not mean that they're doing it now or that they're in possession of the item that they used 2 months ago. So I would be very careful about, kind of time frames. Again, this is like one of those kind of common sense areas where that prevails. So I just received another question. If you come into the bathroom and a student motions or looks at other students, is that reasonable suspicion? I would say just this alone, probably not. Just looking at a student doesn't really mean that like, does that mean the student that's doing the looking is doing something wrong? Or does that mean the student that's being looked at is doing something wrong? This really, you can't, there's not enough in this situation. There's probably not really enough facts to kind of point to that, and you have to be able to say, what is this person doing wrong? And if students are just looking at each other, you can't really, maybe you can ask, like, why are you guys looking weird, looking at each other weird, but, and then, sorry, there's also another question, and then it's more than one person in a bathroom stall. Yeah, this would be a little weird, but again, you don't really know, unless you know why you have facts to support why there's two people in there. Again, I would be careful of just kind of blanket searching at that point. Of course, like I said, it's always best to start questioning students because they might say stuff that would then lead you to have reasonable suspicion. So let's move on, and I will go to the next slide, please. So now that we've discussed kind of traditional searches of students and their backpacks and kind of their outer clothing, let's get into searches of other locations in school. So locker searches. This, unfortunately, is one of our big first kind of gray areas where the law doesn't have a consistent answer across courts. Courts throughout the country treat locker searches differently, and there's not a consistent answer about whether school officials need reasonable suspicion to search a locker or they can just search it at any time. Some courts have said that school property or lockers are school property, students have no expectation of privacy in them, and then they can be searched for any time, for any reason by school officials. Others have said not so much because, lockers are individually assigned to students and that they're given individual locker combinations. So, the students do kind of have a little expectation of privacy in their lockers. In this situation, as far as it comes to locker searches, I think it's better to be safe than sorry and to only search a locker if you have reasonable suspicion to believe that contraband would be found inside the locker. This isn't a different standard from what I was just talking about, but some courts have said you don't need any suspicion at all to search a locker. I would be hesitant to do that. In the search and seizure policies that I've looked at, that's what we've recommended for schools to do. And then also, for whatever this is worth, the New York City public school system, their policy is to not search lockers unless there's reasonable suspicion to believe that the student has put some sort of contraband in the locker. And then kind of regardless of, just again, to be careful, regardless if you want to, whether you're searching a locker or not, with any sort of suspicion, backpack or other closed personal items in a locker, you definitely need reasonable suspicion to search those. The rules are the same. They don't change just because the student doesn't have it on their back at the time that you're trying to go through it. Okay, shared unlocked desks are likely a different story. These can be searched for any reason at any time because they're school property. They're not assigned to specific students. They're usually shared between students, so the students don't have any sort of expectation of privacy in them. So they don't have a lot of Fourth Amendment protections in this area, and you don't need reasonable suspicion to go through, unlocked or shared unlocked common desk. Next slide. Okay, now I want to talk about metal detectors and how they can be used and where they can be used. So there's two big kind of areas where they like to be used. There's at school, and then there's at optional school-sponsored events that are either on campus or off campus. That distinction doesn't really matter, but we'll first talk about at school. So first is kind of the airport-style walk-through detectors at front entrances. Not a ton of schools have these, but the courts have unanimously held that these are totally permissible to require students to walk through them every morning when they enter the school, and there's kind of you don't need any suspicion to require that. It gets a little bit different when we're talking about kind of individual metal detector wands of individual students. If you're going to pick out and target specific students for metal detector wanding, you really should have a reasonable suspicion for doing so and a belief that scanning them will reveal some sort of contraband. Not only is this a much more personal intrusion compared to a walkthrough detector, but it's also targeted. Like with the walkthrough detectors, every student does it. With this, you're singling out a single person. That's fine if you have reasonable suspicion for doing so, but doing it just because you want to or just randomly, that could lead to some trouble, especially if the student believes that they're being targeted for a specific reason or a specific protected characteristic. Kind of only wanding individual students when you have a reasonable suspicion to believe that they're in possession of contraband eliminates all these side issues. Next, school-sponsored events. Prom is the big one here. Wand detecting of all students as they come into prom without any suspicion is totally permissible. You're allowed to do that. But you should be careful because there's a couple landmines in this area. Any wand detecting, regardless, this is kind of regardless, but it should be done by a school official who's actually trained to use the device, and it shouldn't be done by a parent or a volunteer at prom. There's a federal case in New Mexico where everything started off fine, but then the line to wand the students was taking too long, so they started to just skip students and put them at randomly, and then they started doing pat-down searches because the wand stopped working. That would definitely be careful. So be careful to do it uniformly. Avoid actual pat-down searches. Like if you're wanding all students, don't start touching their clothing, because that gets into more serious and more traditional searches, which suspicion is going to be required for that. And then also another thing to keep in mind is, if a student comes, they see that there's a metal detector, and then they walk away, you can't chase them down and you can't punish them for choosing not to attend an optional event. So if they choose not to be wanded, you can't punish them for doing that. Next slide, please. Another big area of search and seizure law where there's a ton of different rules is the use of canine dogs to do searches, or police dogs. And when I say, canine sniff or dog search, I mean specifically trained police dogs. School officials should never be doing this on their own. As you've seen at the airport, the police have specifically trained dogs deployed by specifically trained officers to do this. Kind of by way of example, your superintendent's golden retriever should not be used to kind of search students or used in the school for any sort of law enforcement purpose. Okay, so there's a lot of rules, but this is kind of the most important ones for dogs. You do not need individualized reasonable suspicion to use a dog to sniff school property. So lockers, desks, classrooms, hallways, parking lots, those sort of general areas, you don't need to have reasonable suspicion to deploy a dog in that area. Using a canine dog to sniff students' personal belongings, so let's say their backpack. This you should absolutely have reasonable suspicion for doing this, because again, you're targeting students' personal belongings. And then if this happens, you should remove the backpack from the student's immediate possession so that the dog can sniff it. And then there shouldn't be other people unrelated to the search in the room, as it's going on. And then canine sniffs of an actual student's person. I would recommend avoiding this if you can. Some policies that I've looked at even said that, we're just not going to do this at all. That's probably not a bad way to go. But the good thing about, all the rules around canine sniffs is, if we're getting to this point, outside law enforcement is going to be involved, because without them, you wouldn't have the dog on school property. So, I would always confer with them. They're going to be trained, and they're going to help you kind of navigate, where and when and how to deploy these dogs properly. Next slide, please. So questioning of students. As I said earlier, just questioning a student is not a search. School officials have the right to question students about stuff that they aren't supposed to be doing. So that's totally permissible. And unlike the police, students are not entitled to be read Miranda rights when they're being questioned about their wrongdoing. There's a clip or a picture from a great scene in 21 Jump Street where the main characters are police officers, and they don't even know the Miranda rights. Luckily, when I say Miranda rights, I'm referring to, you have the right to an attorney, you have the right to remain silent, those sort of things. You don't have to worry about that when you're questioning your students. Okay, next slide, please. School resource officers and SROs. SROs are a big new addition to this area of the law recently, and their use in schools has become much more prevalent. When I say SROs in this context, I'm referring to those officers that are employed by outside local law enforcement, but they work within schools. All the rules for searching and questioning, including the reasonable suspicion standard that I've gone on and on about, apply to SROs in schools if they are acting for the purpose of the special needs of school security. So what are examples of special needs of school security? Drugs, alcohol, weapons, things of that nature. Their focus really needs to be on, ongoing school security or ongoing school safety measures. If they were operating in that context, the rules that apply, they're treated the same as school officials as far as, the suspicion necessary to search and do that sort of thing. Where this gets tricky is if an SRO is directed by their agency to take some action in the school that is unrelated to the ongoing security of the school. So, for example, an SRO wants to search a student's backpack because the police told him, or the police think, that the student was involved in a off-campus robbery a week ago, and one of the stolen goods, which is not necessarily a weapon or anything, but a radio or a personal item or whatever, might be in the student's backpack. This is not an ongoing crime because it happened a week ago. Whether the student is in possession of a stolen cell phone or a stolen radio has nothing to do with school safety. This is a purely law enforcement problem, and the rules for school searches are not going to apply to SROs situation. Another bad example of this comes from the New York State Attorney General released a guidance letter in 2019, and it said, SROs should under no circumstances question students about their family's immigration status or their citizenship status. Whether citizenship status and immigration status has nothing to do with ongoing school security, and it's kind of outside the SRO's role as keeping the school safe. So in those situations, they're going to be treated as normal law enforcement officers. Next slide, please. Finally, I just want to give some warnings on how school officials should interact with outside law enforcement agencies. Again, the rules for searches by true law enforcement officers on school property are going to depend on why they're doing the searching. If it's because there's an ongoing crime or school safety issue, the rules for school officials will apply to them. Police questioning of students. The police are really not supposed to come to school and just randomly question students. There's two ways that they can do that. One, if the student is committing a crime on school property or is in the process of committing a crime, obviously at that point the police, can come to the school and kind of question the student about, what's in their possession, if they're in possession of a weapon or drugs or that sort of thing, or if they have parental consent. Regardless of but the police can't just come to school and question students about a robbery that happened last week unless they have parental consent. Regardless of whether it's parental consent or there's an ongoing crime, if the police are interacting with a student on school property, it's important that the parent or guardian should be notified. And then removal of students from school property by outside law enforcement. They can only do this in a couple situations. One, parental consent, again, obvious. If they have an arrest warrant signed by a judge, they can come and remove a student. Or if they observe a student committing a crime on school property, not just a violation of the school rule. It has to be an actual crime that they can be arrested for. Next slide, please. I believe we're getting down to the end. Just quick note on documentation and parent notification. Anytime you do a search, you really need to document, why are you doing that search? What is your basis for reasonable suspicion? Where are you searching? And what did you find as a result of that search? Same thing, if you notify a parent, if you find illegal or prohibited items on a student, you should notify the parents. Next slide, please. And that is it. I will say we are here to help. We've one of our school clients in Rochester, near Rochester, recently wanted us to review their search and seizure policy. In doing that, we found a lot of kind of inconsistencies and very not helpful language. So we were very happy to do that. If you think that's something that you would benefit from, definitely either reach out to me or the bond attorney that you're regular contact with. I see a couple more questions in the chat. I will try to get to them. So the question is using a metal detecting wand permissible? And if it goes off, but is within the clothing, should the law enforcement be called, or if the student doesn't surrender the item? So I guess kind of this depends where, you know, let's say you wand a student and the metal detector goes off and they refuse to take it out of their pockets or wherever they're holding it, and you can pat them down, from the outside of their clothing. And if it's in their pockets, obviously you can remove it from their pockets. You pat them down, you feel something that you might suspect is a weapon or anything like that. If you can get to it without having the student remove their inner clothing, then I would just do that. If you can't, then I think at that point, especially if you think it's something serious like a gun, that a metal detector would be a gun or a knife that a metal detector would be setting off, I would at that point get law enforcement involved. Would it be okay to randomly wand students upon arrival? Um, yeah, I think yes, if you're doing it as like a walkthrough metal detector search, where every time, whether you're using a metal detector, a walkthrough detector, or a wand detector to wand, scan all students as they come into school on an everyday basis, I think that would be fine. Again, if you're just kind of doing it, on Mondays and you're picking out, certain students, I think that's when it becomes a problem. But if you're doing it uniformly, that's fine. School-wide badge searches. I would say definitely do not do this. The students, the badges are their personal property. Um, I guess I should rephrase this. If we're doing in the context of metal detectors, having all the students walk through a metal detector with their bag, that's fine. If you're actually going through by hand and searching every single bag and feeling up every bag and putting your hands in there, that I think would be a problem, especially if you don't have reasonable suspicion. So Kathy, could you put the first slide up with my contact information? And then, so like I said, if anyone needs to go, feel free to, we've reached our time limit. I do have one more question I'll try to get to. This is my contact email and phone if anyone wants to reach out to me. Another question is, can you please restate the point about SROs acting as law enforcement and searching outside of the special needs of school security point? So sure. This is, if SROs are trying to search a student for a reason that has nothing to do with ongoing school safety. So if the SRO thinks the student has a gun in their backpack, that's obviously that has a law enforcement component because it's a crime, but it also is very important to school security. So at that point, the SRO is treated the same as a school official. It's when they're acting purely in a law enforcement capacity outside of school security. So I'm trying to come up with another example off the top of my head, but really when the police want to question or search students based on, past conduct that took place outside of school, that is, doesn't really affect the safety of the school. So if the student isn't doing anything wrong inside of the school or doing anything impermissible inside of the school, then the SRO's authority is going to be different compared to if the student was doing something impermissible or committing a crime or doing something unsafe inside the school. What about, there's another question as well. What about luggage searches before an overnight trip with prior notifications to family and students? Um, that's an interesting question and one I probably, I see this is from Katie. Probably I don't really want to hazard a guess at this point without doing any interesting research because there's just kind of a lot of different competing interests in that question, and it's a pretty interesting question. Um, I definitely gonna, Katie, I will look into it. And then feel free to reach out to me individually after this. But I will also kind of take a look because that's an interesting question, and I'd love to know the answer to it. But okay, I'm seeing no more questions. Everyone, thank you so much for your time this morning. I've really enjoyed giving this presentation. Have a good rest of your day.